me that he has a lot to say today, so.
I tend to ramble, so.
Okay, well, anyway, I'm Donna Pendergrass, president of Mid-South MGMA, in case I have not met you and introduced myself to you. And this year, it's our goal to continue to get to know everybody better and build better relationships in reaching towards more memberships. Next month, our meeting is going to be a breakfast meeting, and we're going to have that meeting open for bringing a guest. We would love to encourage you. If you have a colleague that you feel like would be a good fit for MGMA and would like to expand their horizons, we would love for you to bring them. So be sure to sign up and bring a guest. All right, so today we have a volunteer speaker, which good on him. Well, he went way up on the list when he did that. So,
I'm on the bottom totem pole of the board, so that's all I got to say.
So Andrew Alderman. Andrew Alderman is, I want to get your title correct here, Executive Director and General Counsel for Mid-South Nephrology Consultants. And so we have our own kind of in-house counsel at Mid-South MGMA. Thank you very much. And I'm going to let her get started.
Great, thanks Donna. She's a wonderful president. She does a fantastic job. I've been blessed to be on the board for over a year now, and it's been a great experience. Love to get to know a lot of y'all. MGMA has been a huge part of my journey in healthcare management, as I'm going to talk about here in a minute. So just a couple of things as we get started for housekeeping purposes. This is my disclaimer. Please read it very quickly. I'm not going to go over all of it, but it basically just says, I am a licensed attorney. I'm licensed in Mississippi. I don't know anything about Tennessee. Please don't ask me Tennessee law questions. And nothing that I say up here should be construed as legal advice. I would be happy to answer questions towards the end of the presentation, but more like generalized questions. Don't tell me the specific thing that somebody did to you. I went to the ER one time when I was in law school, and the nurse taking my vital signs asked me what I did. I said, well, I'm a law student. She started telling me all about her estate problem with her mom's will and things like that. And I'm like, please don't do that. So a little bit about me. I'm originally from Central Mississippi. Graduated from the University of Mississippi with a BA in Poli-Sci back in 2010. And I completed law school in 2014. I finished with honors, clinical depression, and a mild to moderate drinking problem. I spent 8 years in private practice. I did all kinds of law. If you can imagine the type of law, I probably did it. Federal criminal defense, child support enforcement, workers' comp, a little bit of plaintiff stuff. I accidentally worked for one of those billboard lawyers for 2 weeks. That was the worst 2 weeks of my entire life. So since 2023, in May, I took over as Executive Director of Mid-South Nephrology. We are a single specialty physician-owned practice. We've got 8 doctors, 5 nurse practitioners, 7 clinics across 3 states, and we service about almost 20 dialysis units altogether. So we know a lot about kidneys, and it's fun. I like it. So just a couple of housekeeping things again before we get started. I want to give a really big shout out to MGMA for helping me put together this presentation. When I took over this job, I had absolutely no idea what I was doing. I had never run a business, didn't know anything about healthcare, and I took all the healthcare classes I could find on the MGMA website, from the national chapter specifically, and that was a tremendous benefit to me. So I know most of you are probably familiar with this, but this is the body of knowledge that they put out for the certification exam. This one is on human resource management, which has a very thorough rundown of the healthcare employment laws that we're going to talk about in a little bit. And then the risk and compliance management volume covers a lot of the compliance things that we're going to talk about, including HIPAA, Stark, anti-kickback, all that kind of stuff. So I wanted to start out though with just a couple of general legal principles instead of diving straight into the healthcare specific things. Because one thing I've learned in my role especially is I deal with a lot of contracts. And so I don't know how many of y'all are in the level at your organization where you see a bunch of contracts. But in your personal life, you're also going to run into contracts. Everywhere you go is a contract. All those terms and conditions that you slide through on the websites and click the button, all those are contracts. So I wanted to give you a couple of examples of things to look for in contracts, especially in your medical practice, that can help you, avoid common pitfalls, make sure that you are setting your organization and yourself up for success. So the very first day of the very first semester of your first year in law school, the first class you take is contracts, because contracts sort of form the foundation for a lot of different areas of law. A contract has three elements: an offer, an acceptance, and consideration. Consideration is just anything of value that you are trading between yourselves. It can be services, it can be money, it can be, foregoing something, it can be all kinds of different stuff. Leonard v. PepsiCo is the case that they use to teach us offers, and I always like to talk about it. In 1997, Pepsi introduced a program called Pepsi Points, where you could buy Pepsi and you would gather points, and they had a commercial that would show you all the different things you could buy with Pepsi Points. Concert tickets, random swag, all sorts of stuff. At the end of the commercial, they flew in a Harrier jet, like one of those very old, big military jets, and had a kid land at his school driving the Harrier jet. And it had a big price tag on it of 7 million Pepsi Points, which equated to about $700,000 in cash. So a guy bought 10 Pepsi Points and then wrote a check for $700,000 and presented it to Pepsi and said, "I would like my Harrier jet, please." And the Supreme Court said, "No, that's not an offer. That was clearly a joke. They were advertising their product. They were never going to actually give somebody a Harrier jet. Plus, where would you land a Harrier jet in school?" Was a specific thing the Supreme Court said. And then another important thing to remember is oral contracts can be enforceable. A lot of people believe that contracts have to be written down. In most circumstances, that is accurate. But if you make a promise for something that is to be completed within 1 year, and it's not over a certain value of money, that could be an oral contract. So if you are negotiating with people, make sure that you are being careful about what you say, and make sure that you have writings backing up everything that you're agreeing to. Finally, the most common contract you guys are going to see is contracts of adhesion, which is a fancy term for like boilerplate language, contracts that you either take it or leave it. You don't have the room to negotiate these types of contracts. They include lots of different clauses that if you want to do the contract, if you want to do the deal, you just agree to it. There's nothing you can do about it. All those terms and conditions on the Apple website are a good example of contracts of adhesion. In personal matters, a lot of times those can be, voided because they're against public policy. But in a business context, they're almost always enforceable, just because you're a business. You should know what you're doing, essentially is what the courts have said. So these are the questions you want to ask when you're reading any contract. What is the term, and does it automatically renew? Is it 1 year, is it 3 years, is it 5 years, is it 10 years? Do you have to give a 90-day written notice to cancel it before the expiration date? Does it automatically renew for successive periods? If it's a 3-year contract, does it automatically renew for 1 year? These are all the kinds of things you want to make sure you know before you enter the contract and sign it. What's the scope of services? What are you required to do under the contract? Usually you want to have a very specific set of things that you are agreeing to do and agreeing to perform. And likewise, when you're your vendors, you want to know exactly what they're agreeing to do. What are the early termination options? If you are unhappy with the deal, is there a way to get out of it? If it's a 10-year contract, do you have a way to get out of it after a year or 3 years? Is there a penalty for that? Sometimes, I think one good one I have is when I got there, we were leasing 3 giant copiers, and they were very expensive. And when I read the contract, they were 5-year leases, and if you wanted to terminate it early, you had to just pay the full price of the copier. So I just have 3 copiers sitting in the corner of my office because I got better, cheaper ones. If the other party breaches, what are our options? If you breach, what are your options? What constitutes a breach? Is there a way that you can cure your breach if something happens? Do you have a period where they have to give you written notice? The other 3 things there are very important, and a lot of things that people don't really know about. Arbitration clauses. A lot of contracts will require you to waive your right to a jury trial and waive your right entirely to go to court. So if they breach the contract, you can't sue them. You have to take them to arbitration. Arbitration is essentially like a privatized version of court, and it can get very, very expensive. Litigation in general is very expensive. Lawyers cost a lot of money, but with arbitration clauses, you're essentially paying for the judge, and so that could be $100,000, $150,000, $200,000. Liquidated damages. A lot of times, especially in like a service-based contract, it's really difficult to know what the damages would be if you breached the contract. So you can have a liquidated damages clause that says, if you breach this contract, I can't determine my damages very easily, so you're going to just have to pay me $50,000. That's what a liquidated damages clause would be. And finally, just watch out for legalese. We learn Latin in law school to some extent, and we like to use very big words. and most of them don't make sense to us. We don't know what we're saying half the time. So it's extra important for y'all to be diligent about that sort of thing. So now we are going to move into our two major healthcare topics. Number one, I believe, is compliance. What is compliance? That's not a rhetorical question. I don't know the answer to it. What is compliance? We partner very closely with Fresenius, like I said earlier, and every one of our Fresenius meetings starts with compliance is all of our responsibilities. Everybody is responsible for compliance. They have never once told me what that means. So, when you're looking at healthcare compliance specifically, it can be just about everything to do with your medical practice. It's HIPAA, it's patient privacy, it's patient security, it's IT security, it's anti-kickback, Stark, you gotta be careful with what kind of deals you're doing. It gets very, very complicated. Now, who in here has had HIPAA training in the past 12 months? Like formalized HIPAA training? All right, good, that's most of y'all. If you haven't had it in the past 12 months, congratulations, you're in violation of HIPAA, and I'm gonna go call the government on you. An important thing to remember is you need a compliance plan. Now, a lot of y'all work for Methodist or another big organization. I guarantee you have compliance plans. If you're a smaller organization like me, there was no compliance plan when I got there. So I had to write a compliance plan. My HIPAA compliance plan is 75 pages, and my general compliance plan is, I want to say like 50-something pages. But it needs to include all of your policies and procedures. And you need to have it written, and you need to have it accessible to your employees so that everybody can know these are our responsibilities as healthcare professionals. You also need to have a named compliance officer, and you need to have regular training once every 12 months for all members of your staff. And that even includes business associates. So even if you are not specifically a covered entity, if you are considered a business associate, which we'll get into in a minute, you also need to undergo regular HIPAA training. Now the compliance plan, this is what you really want to have in it. You need to have an outline of your policies and procedures, not only just for compliance, but also how you report violations. So if you have, it's great if you have something that says, these are what we're supposed to do, but if you don't give your employees a way to report potential violations, that in itself is a violation. So you really want to have a compliance officer, and a committee is best. Having some sort of group of people that take responsibility for compliance is the best way to do this. You really want to have these specific things included in your full compliance plan. Like I said, we have a separate HIPAA plan, and that's generally the ideal best practice. But you can't just have everything all in one omnibus plan. Now, another plug, this isn't sponsored, but MGMA has pre-created compliance plans. You can go on the MGMA website, and they have a full compliance plan and a full HIPAA plan. And they have ways for you to customize it. So it's a few $100s, it's not cheap, but it's cheaper than getting a lawyer. And it's been vetted and it's really good. I mean, I've read it, I used it as the basis for a lot of my stuff. So if you don't have a compliance plan and you're in the position where you can get your organization to get a compliance plan, that's a very easy way to do it. So, fraud and abuse. When I was in law school, I took a class, an entire semester-long class, just on fraud and abuse in healthcare. Because this is such a major topic, and it impacts just about every part of your practice. Now, there are some things that, depending on what your role is at your job, you may not have to deal with very often, like Stark, or the anti-kickback statute. But, False Claims Act, that touches just about everything. The Civil Monetary Penalties Act touches a lot of stuff. So fraud, this is the definition from the government, is an intentional submission of false information to gain money or property. You cannot accidentally commit fraud. Fraud requires some sort of intent behind it. If you accidentally commit fraud, that's abuse. Waste is practices resulting in unnecessary costs to Medicare. One of the things you notice about all the federal laws is they specifically say this has to be tied to a beneficiary under a federal health plan. So that's Medicare or Medicaid. Because that's the only way Congress can really regulate things is if it's in interstate commerce. So you'll see a lot of state laws that may touch more patients than that. But for federal laws, you're generally talking about Medicare and Medicaid. Your contracts with your payers, your private payers, will almost always have the same things in there. But for the legal purposes, we're talking specifically about Medicare patients. So like I said, intent is the difference between fraud and abuse. And then you also have to be careful of what's a criminal penalty and what's a civil penalty. Stark law violations are civil penalties, and a kickback statute violations can be criminal. Criminal just means you could go to jail. crimes are generally the things that you think of when you think of a crime: assault, battery, talking in a movie theater. Civil penalties would generally just be money, or potentially exclusion from Medicare and Medicaid for a certain period of time. So the two major fraud and abuse laws that you have to be aware of, but not necessarily dive headfirst into. Stark is the anti-self-referral law. That basically says if you are a healthcare provider of designated health services, you have to be careful when you're entering into any agreements that provide money to you. Because if you are referring patients to a place where you have a financial interest, that could be a violation of Stark if it is not fair market value. Because, imagine the situation, like you are a nephrologist who owns an imaging center, and you start sending all your patients to that imaging center for kidney biopsies or for kidney ultrasound. Imaging and radiology, stuff like that, is a designated health service. And so if you are giving yourself, some sort of monetary benefit by sending those patients there, it has to meet fair market value and do all sorts of other stuff. So like I said, it's only really applicable, or you really only need to know a lot about it if you're in specific roles within your organization. And kickback statute is a little bit more broad. It's illegal to receive remuneration for referring patients for any services payable by a federal healthcare program. Remuneration has a very broad definition. You normally think of getting money, but it can also be, discounted services. It can be all kinds of stuff. Like I said, that one can have criminal penalties, but will often just be civil penalties. All this has to do with referrals. So if you refer patients to any service or to anybody, you've got to be careful with what kind of relationship you have with that entity. Now, this is one that actually can impact you very directly. The civil monetary penalties law. First, for those of you who work for a hospital system, hospitals are not allowed to pay doctors to reduce or limit medically necessary services. So if a doctor thinks something is medically necessary and the hospital just wants the patient gone, you can't go say, hey doctor, I'll give you $100 if you discharge this patient. That's bad, don't do that. You also cannot give remuneration to Medicare beneficiaries if the provider knows or should have known that such remuneration would likely influence the beneficiary selection of a provider. What that essentially is saying, you can't give gifts to patients or money to patients in order to convince them to come use your services. That does have a couple of exclusions. First of all, you can't do cash or cash equivalents ever. So no gift cards, no anything like that. You can do coupons. Don't know what the difference is between a coupon and a cash back, but whatever. And there's a limit of $15 per gift and an aggregate of $75 in 1 year. One of my doctors texted me at Christmas time and said, listen, we've got this patient. She's 20 years old, she's autistic, she's on dialysis, and her dad is in the ICU about to die. I really want to buy her a gift. I was like, okay, you can buy her a $15 gift, or you can buy her 3 $15 gifts, or 4 $15 gifts, as long as you don't exceed this. Well, I want to buy her a Nintendo Switch too. You cannot buy her a Nintendo Switch too. I don't know how to stress that any more clearly. So he ended up getting her, just something small, just a token. But anything above that, you can get in very serious trouble. Finally, you can only waive copays or coinsurance on a case-by-case basis upon a determination of financial hardship. That means you cannot have a policy that all people under this particular group, their copays are automatically waived. That sucks in a lot of situations because I know when I got to my job, we just automatically waived copays for all dialysis patients because, they're on dialysis. Most of them aren't going to get off dialysis. So we want to try to help them as much as we can. You have to have a formal determination of financial hardship. So we have a financial hardship policy now on the books. That's extremely broad. So I do forgive most co-insurances and copays for dialysis patients. But that's because we go through this very formal process of declaring them to be, financially hard up. So this also applies to your contracts with your private payers. If you waive your copays or co-insurances, that can be a breach of your contract. So when you're trying to be nice to people, which I do all the time, I try really hard to be nice to these people, no matter how many names they call me. You have to be very careful with it and make sure that you're following your plan specifically. False Claims Act. This one has been in the news recently in town. This is knowingly submitting false claims to obtain property or payments from the government. This was originally created in 1863 because defense contractors were not supplying things to the government for the Civil War that they said they were, and Congress said, stop that. And so they created the anti-kickback statute, or the False Claims Act. For healthcare purposes, this generally means if you submit any claim to the government, whether for healthcare related things or not, that the government has to pay for. If it's false, oops, you can get penalized up to triple the government's costs. That's called treble damages. So if you file a claim for $500, you're going to have to pay them back $1,500. Or in the case of this particular doctor here in Memphis, you could submit $40,000 for dialysis charges of patients that you never saw and have to pay them almost $400,000 in damages. Because that's not just the treble damages, that's also attorney's fees, as well as other penalties that they're allowed to enforce on you. Now, the big thing with the False Claims Act is 90% of these claims come from whistleblowers. 90%. So this is not the government going in and finding problems. This is people leaving your organization, going to the government and saying, hey, there's a problem. This doctor in particular had a nurse practitioner. It was just him. Like, he's a solo practitioner, and he brought in this nurse practitioner. And he pissed her off. And she quit. And she went to the government. Because I will tell you the truth. I can guarantee you that every single organization in here has submitted at least one false claim. Like, it just happens. Because you're submitting so many claims for so many services from so many doctors and so many nurse practitioners. Something on one of them is going to be wrong. And so if a whistleblower decides they don't like you and they want to get back at you for firing them or for being mean to them or whatever, they can do that. And they get a chunk of that money. So that whistleblower, I don't know if she's going to get anything, but you can get a significant cut of the money that goes to the government. So being a whistleblower in healthcare specifically can be very lucrative, in case any of you are looking to early retire. Since none of you work for me, I feel free saying that. Okay, now we're going to talk about HIPAA. Yeah! Pop quiz. How's it spelled? A, HIPAA, or B, HIPAA?
B.
That's right, the answer is C, HIPAA. Very good. The Health Information Portability and Accountability Act. I've heard all kinds of different ways of spelling it and what that means and everything, but that's what it actually is. It was originally created in 1996. The way they told us in law school, I don't know if this is true, I couldn't find any sources backing this up, was that a nurse at a hospital in 1996, they had a very rudimentary EMR system, and she brought her son to work, who was like 10 years old, and she left the room with him in there with the computer unlocked, and he got onto a bunch of people's records and started sending them messages telling them they had tested positive for AIDS. And there was no law against that, so they created HIPAA. Again, that might not be true, but it's funny anyway. This specifically covers the gathering, storing, and communicating of personal health information. What qualifies as personal health information? Anything you can think of that has to do with a particular patient that is particularly or personally identifiable to that patient. So that is personal information, their demographics, address, name, sex, date of birth, etc., and individually identifiable health information. So that's if you have their medical record and it has their name on the top of it, ta-da, that's PHI. Now, if you redact it, it may not be PHI anymore. It just kind of depends on the circumstances. The main part of HIPAA is, of course, the privacy rule. This established covered entities, which are particularly health plans, providers, and clearinghouses. So if you don't work for a health plan, a provider, or a clearinghouse, you are not a covered entity. But you are probably a business associate. That is a third party that works with or provides services on behalf of the covered entity. So I have a third party billing company that does all my billing for me. And so they have access to all of our patient records, all of our demographics, everything. We have a very specific business associate agreement. If you are working with anybody and giving them any access to your patient records, you have to have a business associate agreement. It has to be written, it has to be a full contract, it has to outline what they are allowed and not allowed to do with the patient information. So be very careful and make sure that you have a BAA for every entity that has any access whatsoever. Your IT company, your billing vendors, anybody, if they have access to your PHI. Uses and disclosures. And I know y'all have done a lot of HIPAA training, so I'm going to kind of breeze through HIPAA so we can get to the fun employment law stuff. Required disclosures, you have to give it to a patient if they ask for it, or their personal representative. Again, you want to have a signed HIPAA form stating, this is my personal representative. And if they don't have capacity to say that, if they come in the hospital unconscious or something like that, there's all sorts of things. Talk to your in-house counsel, don't ask me. You can do these things without authorization. You can give them to the patient. You can disclose them for treatment, payment, or healthcare operations. the government does not define what qualifies as healthcare operations, so use your best judgment, or talk to a lawyer. Opportunity to agree or object. This is an extremely technical thing where they give informal permission. So if you walk into a room and say, hey, your mom called and asked, can she have your medical records? You don't technically have to get them to sign something, but you should get them to sign something, because informal permission like that, they can just come back the next day and say, I never told you you could give my mom my medical records. Blah, 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 etc. Signed authorizations. I did workers' comp defense, and so my entire job was reading medical records. Just medical records, medical records, medical records. And we had to have signed authorizations from even those claimants. So even as the attorney's going against them, one of the first things we had to do when we opened a case was get the claimant to sign the HIPAA authorization so we could get their medical records. You want to make sure that is with every single patient. If you are sending their medical records to anybody, a law firm, anywhere, make sure you have a signed authorization. There's also a separate authorization that has to be done if you have psychotherapy notes. Not entirely sure why that's singled out by itself, but it is. HIPAA was updated to include the HITECH Act, which created the security rule. The security rule was generally part of the scheme to get people to use EHR, because it was getting a mess with all the paper charts and all that sort of stuff. So the government decided it was a good idea to incentivize using EHR. But if you're going to incentivize EHR, you also have to have specific regulations and rules about how you use EHRs. So those are the reasons behind it, but the things you really need to know, you need to have administrative safeguards. That includes plans, policies, procedures, trainings, business associate agreements, and regular analysis. Second, you have to have physical safeguards. That includes facility, workstation, and device access. Key cards at your front door, making sure that is also really important to have technical safeguards, like requiring reboots for system updates. So we'll talk about technical safeguards, because that's the thing that a lot of people don't really know about. My predecessor told me, oh, we're very HIPAA compliant. We're completely HIPAA compliant. We're the most HIPAA compliant people you can imagine. She's a 75-year-old tiny Spanish lady about this big. I was like, you don't even have a firewall. You're using Gmail accounts instead of secured. You don't have any written plans. There's nothing. So that was a whole conversation that we had to have. But there's an important note about data at rest versus data in transit, and this is a very particular IT thing that I was also the IT guy in my 40-person law firm, so I had to learn about all this too. We use a remote EHR, so we remote into it essentially. So the EHR is not stored on any of our servers. We don't have a server or computers that house PDFs or anything like that. We don't download anything. It's all done through Citrix because we're on Epic. And so all of the information is stored somewhere that is not my place. So my predecessor's thought was, well, I don't store any of the information, so I don't have to do anything about it. No, because that's data at rest. But you also have to protect under the security rule data in transit. So that means anything going in and out of your network has to be protected. So you have to have firewalls, you have to have encryption if that's necessary, because while it is going back and forth through your network, that's your problem. You also cannot rely on third parties to take away your responsibilities under HIPAA. So just because you have a company that houses all of your EHR and your PHI, it's still your PHI. And so at the end of the day, you are responsible for making sure that it's protected. Administrative safeguards. You must adopt reasonable and appropriate policies and procedures. What does that mean? I don't know. Nobody knows. Just use your best judgment or talk to a lawyer. The really important thing about HIPAA is that it's scalable. Specifically the security rule. The privacy rule is pretty much set in stone. You have to follow the privacy rule. The security rule looks and takes into account how big your organization is. If you are a single doctor by themselves, you don't have the same responsibilities that Methodist does. Methodists will have completely different things that they have to do that you don't have to do because it's too expensive or it's too technologically cumbersome. So if you're getting investigated for a HIPAA violation, these are the sorts of things they're going to look at. They're going to look at the size, complexity, and capabilities of your organization. They're going to look at your technical infrastructure, your hardware, and your software security capabilities, the cost of other security measures that you could have gotten, and the probability and criticality of potential risks to each EHI. That means how likely are you to get hacked? If you're stirring cardiovascular, the answer is very, apparently. If you are other places, the risk may not be that great. So the things you have to do, the measures you have to put in place, you can take this into account, and the government will work with you and say, yeah, you're 2 people, this was fine. A really good way to do this, and what I did, I have a third-party IT vendor. They're great, I love them. They have a very particular set of compliance packages that you can buy, and that is scalable to your organization size. So on their advice, we have certain safeguards, certain firewalls, certain encryptions on our laptops, those things that are within our budget, but would meet the criteria of high tech if we ever got audited. So here's some common HIPAA issues that you may run into. Number 1, snooping. My best friend's ex-girlfriend is in the hospital. I'm going to go look and see why she's in the hospital. And then I'm going to post it on Instagram. Is that a thing that people post on Instagram? I don't know. That is probably the single biggest thing, and the thing that people get busted for the most is getting into people's medical records when you don't have a reason to be there. I've gotten calls from Baptist multiple times about one of my doctors in particular who has a habit of his family goes to the hospital, he wants to see what's wrong and see if he can help. So he will pull up their medical records. Please stop doing that. I'm tired of getting yelled at by Baptist. Failure to perform a risk analysis. You can get busted and you're in violation of HIPAA if you don't conduct a regular risk analysis. What is a risk analysis? There are things called pen tests, which are penetration tests, where a white hat hacker tries to get into your network, and if they can successfully do it, you've got a problem. And then that helps you identify problems in your network. You want to make sure that you're doing those occasionally, once every year, once every couple of years, something like that. Denying patients access to their records. They call, they want their records, you have a certain amount of time to give them to them. That depends on local law more than anything. And if you don't do that in time, you violate HIPAA. If you don't have correct BAAs, which I've talked about extensively at this point. Improper disposal of PHI. You were required to keep records for a certain length of time, and when it's time to get rid of that PHI, if you don't do it right, you're in violation of HIPAA. So these are the things that, according to research, are the most common HIPAA problems. So be on the lookout specifically for snooping. Okay, we're done with compliance. Any questions on compliance? Please don't ask any questions, I don't know the answers. Excellent. All right, so now we're going to talk about employment law, which is everybody's favorite. These are just a few of the hundreds of laws that impact employment. State law plays a much bigger role in employment than it does in general healthcare administration. So these are just the federal laws. We're going to talk about the requirements under that. I've got a couple of Tennessee and Mississippi specific things to share, but most of this is high-level federal law view. OSHA, everybody know what OSHA is? Occupational Safety and Health Administration. The Civil Rights Act, the Americans with Disabilities Act, the supposed to be the FLSA. I was backwards yesterday, I guess. Fair Labor Standards Act, the Family Medical Leave Act, the Patient Protection and Affordable Care Act, which is Obamacare, and the National Labor Relations Board, which is the NLRB that has to do with unions. So we're not going to talk about all of these, but we're going to dive into some of the ones that y'all are going to deal with the most. Occupational safety and health. This is the preamble to the law that was passed, I think, in 1970. Each employer shall furnish to each of his employees employment and a place of employment, which are free from recognized hazards that are causing or are likely to cause serious physical harm to his employees. OSHA gets very granular based on what industry you're in. So construction has different OSHA requirements than healthcare, for instance. Healthcare has very specific requirements under OSHA. So you must comply with all standards and regulations regarding bloodborne pathogens, hazard communication, ionizing radiation, exit routes. You can see the list. A big one is making sure you have OSHA posters on display so that everybody can see this is how you contact OSHA if you think there's a violation. That's a very big thing, is they want to make sure that all employees know that they have the right to contact the government if they believe they've been injured or there's some hazard that they're being exposed to. Trying to think, the only OSHA thing that I didn't deal with it, but before I got here, one of the employees claimed that there was mold in one of these vents right above her desk and she was getting sick. So she filed a complaint with OSHA and they had to do a whole investigation and all kinds of stuff. And there wasn't anything. But, it's a whole process if you have to go through that. So you want to make sure that you are complying with all of these standards so that if you do go through it and you do get reported to the government, you can say, hey, we're following all the guidelines. We're doing everything we're supposed to do. These are the general best practices for complying with OSHA. You want to have a comprehensive manual outlining your policies and procedures. As with everything else we have talked about, you want to have it written down. If it's not written down, it didn't happen, as we like to say in the law. So if you don't have a comprehensive manual and OSHA comes and looks at you, they're going to be like, why didn't you have a manual? You didn't have any policy and procedures. That's bad. You want to make sure you're providing training for OSHA for your new employees, as well as some continuing education. This is not nearly as strict as HIPAA. HIPAA is very, very, you have to do it every 12 months. OSHA, you just want to make sure your employees know. So my employee handbook that I had to write because they didn't have an employee handbook has, all the OSHA guidelines in it. And so when they are onboarded, they have to review OSHA requirements. They have to make sure they know how to submit a violation report, all that kind of stuff. As far as documentation goes, this only applies if you have more than 10 employees. This is another thing with federal laws that we'll see a lot of. Most of them only apply to certain sizes of organizations. Like the Affordable Care Act only applies if you have, 75 employees or something like that. So for documentation purposes, you only have to have it if you have more than 10 employees, which I'm sure most of you do. If you have more than 10 employees, you must keep a record of serious work-related injuries and illnesses for 5 years, including annual summaries. So if you've had 10 workplace injuries in 2025, you actually have to have an annual summary saying these were the 10 workplace injuries that we had. And you have to keep that documentation for 5 years, kind of like you do with your health records. That does not include first aid. They specifically exempt first aid. So if somebody cuts their hand and you put a Band-Aid on it, you don't have to report that. If somebody falls and breaks their leg, you have to report that. And the logs, this is also important, are per office. So like I have 7 clinics across Mississippi, Tennessee, and Arkansas. So I would have to keep a log for each individual office. Again, those are just the requirements of HIPAA, not HIPAA, OSHA. So you kind of run the risk of taking your life in your own hands if you don't follow all the regulations to the T, but just be careful. Use common sense. Finally, workers' comp. I could stand here for 3 hours talking about workers' comp. It was the bane of my existence for about 5 years. Almost all of workers' comp is state-based. So the rules in Mississippi are completely different from the rules in Tennessee, which are completely different from the rules in Alabama. I can't remember the weird thing about Tennessee is you're not allowed to have a defense attorney. So like if you are an insurance company or an employer that gets a workers' comp claim filed against you, you can't go get defense counsel. I don't know why. That was weird. You can in some circumstances, but for the most part, you're just kind of on your own. So you want to make sure that you know what workers' comp is in Mississippi or Tennessee or wherever you're based. And you definitely want to have insurance. In Mississippi, it's a requirement. If you have more than 15 employees, you have to have workers' comp insurance or be self-insured under a particular cap, et cetera, et cetera. All right, discrimination. There are a bunch of different laws about discrimination. All kinds of stuff about discrimination. The big one, and sort of the progenitor of all of them, is Title VII of the Civil Rights Act of 1964. This has been updated throughout the course of history since 1964. Generally speaking, you can't take adverse actions against an employee or a potential employee if they are a member of a protected class, and their membership in the protected class is why you were taking the adverse action. So you can fire a woman. You can fire a black person. You cannot fire them because they are a black person or because they are a woman. In 2020, the Supreme Court included pregnancy, childbirth, sexual orientation, and gender identity under the definition of sex. This was a fun little trivia tidbit for you that I looked up yesterday. If you go to the DOJ website, they have a whole page for this. And they talk about what they will, enforce the laws for. If you look at it today, it does not include any of those things. It doesn't include pregnancy, childbirth, sexual orientation, or gender identity. If you go on the Internet Archive to February of 2024, it does say all that. So make of that what you will. So the big things are age, sex, color, religion, national origin. So you can't fire somebody because they're Muslim. You can't. The big thing with, I know DEI has been a big topic for a while, but one of the big tenets of DEI is making sure you are advertising jobs in communities of underserved populations. So you want to make sure that you are advertising any job openings that you have to as many people as you can, especially people in protected classes. So if you are intentionally not posting jobs in predominantly black neighborhoods or predominantly Muslim neighborhoods or anything like that, that can be a discrimination claim. So you just want to be careful that you are documenting everything. Document, document, document. If you were hiring somebody or firing somebody, if you're going through applicants and not hiring somebody in particular, if you're refusing to transfer somebody or promote somebody, or you're laying off people, if you won't let certain people use certain company facilities, if you won't give some people the same training programs that you give other people, if you don't let some people be involved in your fringe benefit plans, if any of that is true, and it's because of one of those things, that's discrimination. Now, you can do most of those things for legitimate reasons. Like, if you can have all part-time secretaries are not allowed to participate in our fringe benefits, that's fine, because you're not doing that based on their membership in a protected class. What you can't do is say, all women cannot participate in our fringe benefit plan. That's bad, don't do that. Also, Civil Rights Act prohibits negative action or retaliation, so all that stuff at the top, if they complain about discrimination, you cannot retaliate against somebody because they said they were discriminating, you were discriminating against them. So if they say, you're not promoting me because I'm a woman or because I'm national origin, I'm from Canada, then you can't fire them or you can't demote them. You can't cut their pay. You can't do anything like that. Now, you can, again, if you're documenting well and there are other reasons for doing what you were doing, taking the adverse action, that's fine. You will probably get a complaint filed against you with the EEOC, but as long as you have documented everything correctly and you have legitimate reasons for doing what you're doing, it'll be okay, probably.
Is the age 40?
Yes, we're going to talk about, that's another specific law, so it's 40.
That's so wild.
I know.
That's so young.
I'm not there yet, so y'all can't discriminate against me. All right, the Americans with Disability Act. This is way more complicated than I even thought it was when I started looking into this. This is, yeah, you can see. So essentially, you cannot discriminate against qualified individuals, remember that term, in job application procedures, hiring, firing, advancement, compensation, job training, and other employment aspects. It really applies if you have more than 15 employees. If you were in an extremely tiny place, they will give you some leeway. What is a disability? A physical or mental impairment that substantially limits a major life activity. What does that mean? Whatever they want it to mean, essentially. It used to be really just kind of like, people in wheelchairs and things like that is what people thought of when they thought of the ADA. But it also includes like depression or chronic migraines. I have chronic migraines, and so I have lamps in my office instead of the overhead lights. That's a reasonable accommodation that my employers have made for me. Well, I'm the boss, so I made the accommodation for myself. That's not the point. Who is a qualified individual? That is not everybody that is disabled. That is not everybody that applies for a job. Qualified means it is a disabled individual who, with or without accommodations, so even if you don't accommodate them, they can still perform essential job functions. What is an essential job function? There's a whole slide about that. The person also must still satisfy your requirements for educational background, experience, skills, licenses, and other job-related standards. So let's say, for instance, you have a person apply for a registered nurse position. Registered nurses have certain licensing requirements and educational background requirements that they have to meet in order to be a registered nurse. Just because somebody in a wheelchair applies for that registered nurse position, if they don't have any of the credentials, you're not violating the ADA. Now, if they are in a wheelchair and they do have all of that, and they could be a registered nurse even if you didn't do anything to help them, then you run into ADA problems. What are essential job functions? This is the thing that you really need to know. You really need to have a very detailed written job description. So if you are posting a job for the public and advertising it to a bunch of people, you want to make sure that it is very specific and detailed what the job functions are. When I was in workers' comp, we had all kinds of job descriptions that we got to read. Must be able to lift 15 pounds. Must be able to stand for more than 2 hours at a time. Must be able to sit at a computer for more than 3 hours at a time, et cetera, et cetera, et cetera. So you want to have all that written down. And the reason you want to have all that written down is because that is what is considered under this. If the disabled person is able to meet all of those functions, then if you don't hire them because they're disabled, that's a problem. So what are essential job functions? You have to consider whether the position exists to perform the functions. So a front desk phone answerer, the purpose of their job is to answer the phone. So if the person is deaf, maybe they can't answer the phones even with or without accommodations. If they can, like if they're blind, they can answer the phone probably, just depending on how you're set up and So what are the specific functions that the job is created for? Only a limited number of other employees are available to perform the function. I tried to find out what that meant. I don't have any idea. The example that they gave on the government summary was phone answering, essentially. Is like, are only 3 people in your office trained to answer the phones? Then, I don't know, just ignore that one. The function is highly specialized and the person is hired for their expertise and ability to perform said function. So I'm a lawyer, I'm licensed. If I was being hired as a lawyer, that is highly specialized and I'm being hired for my expertise and my ability to perform as a lawyer. So it is essential to that job that I can be a lawyer. If there was something that I was disabled at that made me not able to be a lawyer for some reason, I don't meet the functional, the essential job functions of that job. Another thing that they will look at is the actual experience of past or present employees. Where that will come into play is if you are, we're just going to talk bluntly, if you were discriminating against somebody because they're disabled, because you don't think they can do the job even though they can, if they filed an EEOC complaint, the EEOC will look at what other people in the same job have done in the past and currently. So if you have somebody answering the phones and you don't think they can answer the phones for whatever reason of a disability, they will look and say, well, these other people, all they do is they literally just answer the phone and press a button to transfer the call. That's all that they do. So this depressed person can do that. This person in a wheelchair can do that. So then you could get in trouble. Reasonable accommodations. If you hire a disabled person or have a disabled person doing a job that they are able to do, you are then required to provide reasonable accommodations. This does not mean you have to break your back and destroy your business in order to accommodate that person. It has to be reasonable accommodations. It is a reasonable accommodation for me to have lamps in my office to cut down on my chronic migraines. It is not a reasonable accommodation for them to build me a new office in Hawaii. Does that make sense? So, in order to employ, any change or adjustment to a job or work environment that permits a qualified applicant or employee with a disability to apply, perform the job, and enjoy the benefits or privileges enjoyed by non-disabled employees. This is what I'm talking about with legalese. We just make the most convoluted, complex sentences that could be said much easier. I just copy and pasted that from the government. What does that mean? Modified equipment. If they are, blind and they're answering the phones, get them a phone that has, braille or some other way that they're able to use their voice, maybe just something that allows them to answer the phones and transfer calls despite their disability. Job restructuring or modified schedules. That mean maybe they need to be part-time. Maybe they have, a disability that only affects them in certain parts of the day. Reassignment to a vacant position. If they really can't do the job, you can just move them to a different job as long as they are able to do that. Adjusting training materials and policies. Some people have ADHD. Some people have learning disabilities. They're not able to process information the same way that everybody else does. It is reasonable for you to accommodate those and modify your training in order to allow them to perform the job. Providing interpreters or readers. Again, if you have a blind employee, maybe you need somebody to read for them or something along those lines. Making the workplace readily accessible. Ramps, other requirements that you have to meet for the ADA, just in general. There were amendments in 2008 that broadened the definition of disability to include episodic impairments or those in remission. So if they had some sort of disability that is now in remission, you may still be required to provide them reasonable accommodations in case it comes back. Or if they have an episodic problem. If they have epilepsy and they're treated with medication and it only happens once every 6 months, you may have to have some sort of, you can't discriminate against them because of the epilepsy, even though it's episodic and not a constant disability. It also prohibits consideration of mitigating measures, including medications, when determining what is or is not a covered disability. So I have depression, I'm on medication for it. You cannot use the fact that I'm taking medication to not give me reasonable accommodations. Does that make sense? It's a little weird, but that's pretty much what it says. Age discrimination. Only applies if you have 20 or more employees. So if you have 10 employees, fire all the old people. Please don't do that. Definitely delete that from the recording. Again, as Jessica said, it only applies to people who are 40 or older. So if you are over the age of 40, you cannot be fired, demoted, given a pay decrease, or anything like that based solely on your age. The problem with age discrimination claims that you run into all the time it's really hard to prove that they're doing something to you because of your age. Like, it's really hard to prove. Unless you were a 95-year-old Walmart greeter and they're firing you, that's pretty obvious that it's because you're 95. You have to prove that it is the sole but-for cause. That is where this just gets incredibly tricky. And I mean, it's good, I guess, for the employers, but you know, if you can prove if somebody files an age discrimination claim against you, and you can provide any legitimate justification for the adverse action, it's not going to work. They're not going to be able to do it. It's not quite the same with all the other discriminations. Like those, they're a little bit higher standards, but age discrimination is so hard to prove. There are not a lot of age discrimination claims that make it very far on their own. What you will usually see when somebody files an EEOC claim against you is a bunch of different things altogether. So they will claim age discrimination, sex discrimination, racial discrimination, religious discrimination, disability discrimination. All of it will be kind of thrown together to see what sticks, essentially. So age discrimination almost always comes with a different disability or different discrimination claim. But just be aware of it. The Fair Labor Standards Act. Minimum wage was increased to $7.25 in 2007, and has stayed there ever since. So under federal law, you were only required to pay your employees $7.25 an hour. This does vary locally. There are other places in the country that have raised the minimum wage. They can never go below the minimum wage. It's why it's called a minimum wage, unless you're a waiter or a waitress. I think their minimum wage is $2.20, if I'm not mistaken. And further of all, your benefits must be offered to all like employees. Like employees means essentially employees of the same classification. So if you have a whole bunch of secretaries, you can't offer 3 of them healthcare benefits and not offer it to the rest of them. If they're part-time, that's different. If you have full-time secretaries and part-time secretaries, those are like employees separated. So you can offer benefits to one group and not to the other group. But you can't just pick and choose who you are giving your benefits to. Because I'm sure a lot of doctors would be more than happy to have health insurance for themselves and not offer it to certain people that they don't like. But you can't do that. Wage and hours. Pop quiz again. What is the number one type of theft in the United States on an annual basis?
Overtime.
Wage theft. Exactly. Not people breaking in and stealing things. Wage theft accounts for almost $10 billion in lost wages every year. Most of this has to do with overtime, because overtime is needlessly complicated, especially when you get into exemptions. The general rule I always heard growing up is if you were on salary, you're not entitled to overtime. That is not true. That is absolutely not true. If you are on salary and you don't earn more than $684 a week, you can't be exempt in absent circumstances. Non-exempt employees must be paid overtime if they work more than 12 hours in a day or 40 hours in a week. So if you have people, even if they're only working 36 hours, if they're working 3 12-hour days, they're still entitled to overtime. If they're working 50 hours a week, they're entitled to overtime. Overtime obviously is defined as time and a half, which is calculated based on their base hourly rate. So if they make $10 an hour, they get $15 for overtime. You all know that. Excuse me. So what is an exemption? How do you get an employee that you don't have to pay overtime to? High wage earners generally are exempt as long as they're on salary. So even if you're hourly and you get paid $150 an hour, you can still be entitled to overtime because you're not salary. Does that make sense? So there are, I believe I have 4 or 5 different, there's several exemptions. So here's where the exemptions go, yeah.
What's the 107,000?
So if you make, those are just the 2 numbers that they have on there. So if you make, because they changed it in 2021. This is from the current FLSA government website. These are the current numbers. Because the Western District of Texas put an injunction on the last 3 times that the Department of Labor tried to increase those numbers.
Well, I'm just saying, I recall them looking at changing the salary to like 50-something thousand.
Yeah.
But 684 times 52 is 35,000.
Oh yeah, no, I know. It doesn't, the math doesn't work.
Yeah, so it's weird.
Those are the numbers that are on the website. That's what's in the law. I'm not Congress. The difference is, I mean, the reason that it is so low is you still have to meet the other specific standards. As with a lot of government statutes, these are all and. They're not or. That means all of these things must be met in order for them to be exempt under those exemptions. So for the executive exemption, the primary duty is managing the enterprise or department. I am an executive, like I'm the executive director, I'm over the entire enterprise. If you are over, the radiology department of a larger enterprise, you probably fall under the executive exemption. You must direct the work of at least 2 or more other FTEs. So if you are the director of the radiology department, but for some reason you're the only person in the radiology department, you don't meet the executive exemption. You also have to have either the authority to hire, fire, or promote people, or your suggestions for hire, firing, and promoting are given significant weight by the organization. Does that make sense? Okay, that was the easy one. Administrative. Office or non-manual work directly related to management and general operations. Primary duties include exercises of discretion and independent judgment. Who falls under that? I don't know. Absolutely no idea. When I worked at my law firm, my last law firm, we had paralegals. Obviously, they all made $50,000 a year. They were all on salary. But they really didn't use discretion or independent judgment. They were kind of just doing what we, instructed them to do. They used their expertise, obviously, to do those things. But they didn't really have the room to make major decisions on their own. They also were not performing work directly related to the management or general operations. They were performing, ancillary legal work, but that didn't have anything to do with running the business. My administrative assistant that I have right now, she's hourly, so she gets overtime. But, all of her duties are related to management and operations. But she also really doesn't have the ability to exercise independent judgment or discretion to make major decisions. So I don't even think she would fall under the administrative exemption. Yeah, I know. This is fun, isn't it? I can see where the clinical depression and mild to moderate drinking problem came from. Okay, so professional exemption. Primary work is requiring advanced knowledge, i.e. is primarily intellectual in character and requiring consistent exercise of discretion and judgment. Advanced knowledge must be in a field of science or learning, prick up your ears, must be customarily acquired by a prolonged course of specialized intellectual instruction. Nurse managers very often will fall into that. If they are, they have gone through extensive courses of training, they are in a field of science or learning, and their primary duties are of an intellectual capacity as opposed to the physical capacity. So your normal registered nurses probably are not going to meet this exemption because even though they meet the other parts, they're doing a lot of manual labor. Your nurse managers, that's the specific example given by the DOJ actually, or the DOL. If they're paid salary, they very well may be exempt and they don't qualify for overtime. Again, please consult your own lawyers about this if you're trying to not pay people overtime. Because again, that is the single biggest cause of theft in the United States. And I don't want to see any of y'all's mugshots on the TV. Computer, that's what it's literally called, the computer exemption. If you were employed as a systems analyst, programmer, software engineer, or similar, so your IT guys, the help desk guys qualify for overtime. The guys that are programming all the stuff, if they're paid salary and make at least $680 a week, they probably don't qualify for overtime. Outside sales, and then depressingly for me, teachers, lawyers, and doctors. My first law firm, I made $25,000 a year. That was in 2014. And I worked 60, 70 hours a week, and I didn't qualify for overtime because I was a lawyer. And so none of your doctors will ever qualify for overtime, which is nice, because they work a lot. Meals and breaks. Contrary to popular belief, there is no federal requirement that you give people meal or lunch breaks or anything like that. So you have to check all of your local and state laws. Tennessee, I looked this up for you. 30 minutes unpaid if they are scheduled to work 6 or more consecutive hours. So if you are in Tennessee, you do have to provide a meal break of at least 30 minutes and it can be unpaid. In Mississippi, there's nothing. You don't have to give anybody a break if you work in Mississippi. When I was in retail, I would work 9, 10 hours straight and they didn't give us breaks. That was at a Christian bookstore. But there is one federal law that does apply there. If you offer 20-minute or lower breaks, so like if you give somebody a 15-minute break, that has to be paid. 30 minutes or above does not have to be paid. So, act accordingly. Family Medical Leave Act, FMLA. Up to 12 weeks unpaid job protected leave. That means if somebody qualifies for FMLA and applies and does all the right paperwork and everything, you have to give them up to 12 weeks. You don't have to pay them, but you can't get rid of their job. If they go over their FMLA time, then you can sort of start getting rid of their job. This happened all the time when I was doing workers' comp, constantly, because Mississippi workers' comp law, at least, does not give any job protections. So they would always, the injured workers would essentially use up all their vacation time, use up all their sick time. They would qualify for FMLA, so they would get 12 weeks unpaid. And if they still couldn't go back to work, 99% of the time they would get fired. America, we're fine. Europe, obviously completely different. Other places around the world, completely different. FMLA also only applies if you have 50 or more employees within 75 miles. So if you have two giant offices, 100 miles apart with 49 employees, FMLA does not apply to you. Most of y'all at like larger organizations, obviously, you have FMLA leave. These are the specific reasons that people can qualify. Birth or care of a newborn child. There is no mandate that you get paid maternity or paternity leave. They can take up to 12 weeks after the baby is born. Also, placement of a child for adoption or foster care. One of my best friends has fostered and adopted 4 kids, and he's done FMLA a couple of times. Usually those don't take up the whole 12 weeks. They'll just do a couple of weeks while the kids get acclimated, that sort of thing. Care of a spouse, child, or parent with a serious health condition, so they can take FMLA. That's where the family department comes in. If their dad gets cancer and is going on hospice, they can take up to 12 weeks of unpaid leave to go take care of their dad. Or their own medical condition. That's what I was talking about a minute ago with the workers' comp. Qualifications. So if you have more than 50 employees within 75 miles, the worker has to have worked at least 12 months with you, and they must have at least worked 1,250 hours in the preceding 12 months. So if they've been there for 6 months, they don't qualify. If they've been there for 11 months, they don't qualify. If they are extremely part-time and they've been there for 15 years, they don't qualify if they work less than 1,250 hours in the preceding 12 months. Again, there are no federal or, as far as I'm aware, state regulations around here anyway, that require any sort of paid leave for any of these conditions. So that is up to you and your organizations if you want to offer that. I offer paid maternity leave. I give bereavement. I let my employees go take care of their sick kids and all that kind of stuff. So hopefully y'all do the same. So that's all I have. That QR code is my LinkedIn profile. Please don't use it because I never go on LinkedIn. That's my email address. Feel free to email me. Please don't call me. I don't answer the phone. I'm a millennial. We stopped answering the phone in 2009. So I know we've got a few minutes left, which is why I'm glad we started early. Questions. Broad questions, please. No specific questions that could cause me to get in trouble with the bar. A lot of stuff. We'll go back to the main thing. Employment law questions. Anything at all. Anybody? Awesome. Rock and roll. Thank you, everyone.
I neglected to thank our